My name is Joe Frick, and today we're going to be talking about what legal custody actually is in Idaho. Now, before we jump into the topic, it's important to understand the distinction between physical custody and legal custody because those are two distinct things. Physical custody entails a bunch of different stuff, but what it really boils down to is where the kids are going to live, with who and when. Now, legal custody is essentially the parent's ability and right to choose the major big ticket items in their children's lives, such as education, religion, and healthcare. When we're talking about legal custody, though, that's what we're talking about, the parents' ability to make those big decisions in their children's lives. If the parents can't agree on who is going to get legal custody of the children, the court's going to make the decision. Now, in Idaho, there's usually presumption that there should be joint legal custody, and that is the rule and not the exception. And now, some situations, one parent could get sole decision-making power on some topics, such as if your child has certain medical issues and the other parent is unable or unwilling to get them the care, then the court can make a ruling that one party has sole decision-making purposes just for that specific topic. Now, would there be sole healthcare decision-making, the other parent would still have the right, and you would have the obligation to confer with that other parent about, education and religion. If the parents can't agree, the decision is going to be made by the court. And when the court's making the decision on who should have legal custody, it's same with physical custody. It's always going to come down to what's in the best interest of the children. Now, again, there is a presumption of joint legal custody, and that is the rule and not the exception. When the court's making the decision as far as the legal custody, there are certain factors that they're going to look at, which is contained in an Idaho statute. The court is going to look at children want, what the parents want, the interaction and relationship of the children with their other people in their lives, their interaction and their relationship between the community, there's domestic violence involved, and the big ticket item that's always brought up is the character and circumstances of all parties involved. Deciding whether to do joint legal custody or sole legal custody is, the ability of the parents to communicate with each other. If one parent's doing all of the medical appointments and asking the other party to consent to that, or if they want to come to the appointments, or if they're just unwilling to be a part of that process at all, then the scales would tip more for sole legal custody for that issue. They will look at how far apart the parents' homes are. They'll look at how involved each parent is in the kid's life. They will also look at, if it is a medical issue, how close is the facility to where the parent lives for the child to get care. Now, some of the factors that may tip the scale into one parent getting sole legal custody versus sharing that responsibility is how big of a conflict do the parents have between each other. If they hate each other and they're not communicating at all, or if one parent's using the child as a weapon against the other one related to any of the issues that they have legal custody over the kid, that would tip the scales in the complying parent with getting sole legal custody and the combative parent not having any rights as far as making decisions with the kids. They will also look at see if there is any history of neglect or abuse by either parent, and if that's the case, that's obviously going to tip the scales towards sole legal custody for the other parent. If there's an order for joint legal custody or sole legal custody, that order can get modified in the future so long as there's some certain requirements that have to be met. Now, if you're wanting to change legal or physical custody, you're going to have a permanent, material, and substantial change in circumstances. What that means, there has to be something big that's happened in the parents' or the kids' lives that would justify modifying the prior custody order to make it better for the kids. That's always the issue that the court's going to look at when they're talking about, should I modify this custody order? And if we should, what should we modify it to? It's always the best interest of the children, and the court's going to look at everything that's going on when they're making that decision. Now, there are some circumstances that are going to be kind of automatically included and justified as far as what that permanent material change in circumstances is. And then there's some that we know that if it's just that issue, it's not going to happen. So one of the issues that kind of always makes it a permanent material and substantial change of circumstances if one of the parents moves, especially if that's going to affect that parent or the other parent's ability to exercise their custody rights pursuant to the custody order that's put in place. Now, if one party has a significant mental health issue that comes up out of nowhere, which affects their ability to take care of their kids, that's also going to be kind of deemed a substantial material and permanent change in circumstances. If the child has some issues that are greatly affecting their mental health or just their health in general, that could also be a permanent material change in circumstances. Another issue that would come up would possibly be whether the children are suffering academically in either parent's home. It's, say, if one person is bringing the kid to school all the time, kid's doing great in school, that's not going to be a change in circumstances. However, if one parent is regularly not bringing the kid to school, every time they're at that parent's house, they're not getting their homework done, their grades are substantially suffering because of that parent's actions or inactions, then that would also be concluded as a permanent material change in circumstance that would justify a change in the custody. One issue that comes up that if it's just this issue, it's not going to be deemed a permanent material change in circumstances, and that is the child's wishes of where they let to live. The Idaho Supreme Court has made it clear that if the only thing that has changed from the prior custody order to now is that the kid wants to live with the other parent, that does not meet the permanent material change in circumstances requirement to change the custody order. Now, that being said, a lot of times when we have one kid wants to live with the other parent, there's usually stuff in the mix you can add on top of that that would meet that requirement, such as the grades, the mental health, the relocation, the parents' work schedules change, which could really affect the way that the parents are taking care of the kids. There's a lot of different issues that can be added on top of the kid wants to live with somebody else, so you can meet that permanent material change in circumstances. So you can get to the judge to say, this is why I think we should change it, and then this is what is in the best interest of children versus the prior custody order. So when we're talking about legal custody, we know that legal custody is different than physical custody in that legal custody only applies to the parent's right and ability to make major decisions in their kids' lives.